Hello, my name is Steve Blake. I'm an attorney at the Blake Law Firm, and today I'm going to give a short presentation on handling tenant improvements in commercial lease agreements. And a tenant improvement is commonly referred to as a TI, and what it refers to are alterations or improvements that are made to a commercial leased premises that are designed for the specific needs of the tenant. And for example, you can think of a restaurant where that tenant may need a bar area, it'll need a kitchen, it'll need maybe an office, and something like a yoga studio may need a wood floor or a mirrored wall. And then a laboratory may need something like a workstation or a hazardous waste disposal area. So when the tenant negotiates their lease agreement, typically what they're provided by the landlord is just a blank shell. So 4 walls, a ceiling, and a floor, and then the particular space needs to be customized to suit those tenants' need. And this is something that's typically negotiated while the lease itself is being negotiated. So it's important for both the landlord and the tenant to have a very, very good understanding of what's going to go in the space so that when they negotiate the lease, they can deal with the TIs. And when the lease is actually created, the commercial lease agreement between the landlord and the tenant, you're going to identify what the scope of those tenant improvements are going to be, because when the tenant signs the lease, as I mentioned earlier, they're going to have a blank space that's going to have to be built out. And depending on what the improvements are, it may take 2 weeks to build those improvements, or it may take 6 months. It just depends on the type of business and the improvements that are needed. So what happens is, part of the lease agreement, the parties negotiate what these improvements are going to be, and then they'll typically have as an exhibit to the lease something that's called a tenant work letter. And the tenant work letter can be a multi-page document. I've seen them where they're 2 pages long, and I've seen them where they're 50 pages long. And it's going to go through all the details regarding the construction of these improvements. For example, who's responsible for the construction? Is the landlord going to be the one that contracts with the various contractors to build the improvements, or is it going to be the tenant that contracts with those contractors? And there's advantages to both, and it depends on the landlord and the tenant and the type of improvements, but either one could arguably be the contracting party. So that's something that should be negotiated up front, so there's no confusion down the road as to who's responsible for that. And then also the day-to-day management and authority, which goes hand in hand with the contracting party. Who's going to be the one on site that's communicating with these contractors about the improvements? What happens when work may not be getting done in a timely manner, or the scope needs to be changed. And then another thing that's usually addressed in the tenant work letter is the selection of a contractor and or design professionals. Who's going to be the architect on this project? Who is going to be the contractor? Sometimes it doesn't matter to the landlord or tenant, but sometimes the landlord is very particular about what contractors they want in their property. And then likewise, sometimes the tenant may, if it's a chain type tenant, they may have a particular contractor that they always work with that knows their properties and knows how to build the improvements that they need. So this is, again, something that needs to be negotiated up front and addressed in the tenant work letter. And then also, the lastly I had in here was approved plans and change orders. And this really goes to who gets to approve the final plans, what's the process for doing that, what happens if you're 3 weeks into the improvement construction and the tenant wants to change something, or the landlord wants to change something, who's responsible for that cost and expense, and if there's a delay in doing that. This is all addressed in the tenant work letter. The approval of the plans and specifications for the TIs and the selection of contractors, I just touched on it earlier, but this is an important step in the lease negotiations. And typically what you'll see in a tenant work letter is a pretty detailed process as to how to select a contractor and then determine kind of what happens during these timeframes, because you'll usually see something where there's maybe a list of pre-approved contractors, 2 or 3 that the parties can use. And if for some reason they don't want to use those, there's a process where the parties can obtain bids or estimates from additional contractors and then submit those to the other side to see if it's a mutually agreeable contractor. And one of the things that those provisions always say is that the consent of the other side cannot be unreasonably withheld, which just means that the other side's allowed to look at it and analyze it, figure out if it's something that they want to work with. But if they don't want to work with that contractor, there should be a reasonable explanation for it. Either, they're too expensive, they can't get to the work in a timely manner. It shouldn't be something arbitrary where, they just don't like the name of the contractor or, something that's unreasonable. So both parties have an obligation to behave reasonably in selecting the contractor and approving the plans. Then another important part of the tenant work letter in regard to the tenant improvements is the actual construction of the TIs. Because sometimes if it's a brand new premises and it's a blank shell and the tenant signs their lease to move in, it's fairly easy to get those improvements completed on a blank shell. And it might, let's say it takes 3 to 6 months to do it. The tenant's not going to actually take possession of the property until the improvements are completed. So that's something that's typically addressed in the lease, the tenant work letter, and they'll talk about what the tenant's obligation is to pay rent while this construction is going on. And typically there's no obligation to pay rent, but oftentimes if there's delays or if the tenant's not ready to take possession once the improvements are completed, the rental obligations will be triggered and that tenant will have to pay rent. So it's important to understand what you're agreeing to in the lease on the front end regarding this construction. Sometimes tenant improvements will be negotiated during an existing lease. For example, if the tenant wants to expand its space, the suite next to the tenants opened up for some reason, 2 years into their lease, and they want to take over that space, maybe they'll be able to negotiate some tenant improvements as to that space. Or if the tenant's renewing the lease, sometimes they'll try to negotiate improvements at that time as well. And then one last note here is, while the improvements are being constructed, if for some reason the tenant or the landlord wants to change something, those typically need to be approved by either side before those are agreed to, because that always increases the cost and potentially delays construction. This next slide here is one of the biggest negotiating spots in negotiating tenant improvements, is who's going to pay for it and how is it going to be paid for, at what rate is it going to be paid for. What the tenant work letter typically refers to as a tenant improvement allowance. And this is how much money the tenant is allotted to spend on tenant improvements. And let's just say, to make it easy, that the tenant is given $100,000 allowance. So then the work that the tenant needs to do that is part of the TIs is limited up to $100,000. And anything over that would be the responsibility of the tenant. And the way that it's negotiated between the parties, this is typically negotiated on the front end before the tenant signs the lease. And it's usually done, between the real estate brokers and the parties. Is it going to be a fixed fee amount, like I said before, $100,000, or is it going to be calculated per square foot of the leased premises? This often happens where, you're going to lease 20,000 square feet and the landlord is willing to give you a tenant improvement allowance of $5 per square foot. So then you just multiply the square feet by $5, and that's what you get. And typically the payment and the construction of the tenant improvements relates to the physical improvements only, such as moving walls, installing floors, lights, ceilings. It doesn't cover things like the tenant's furniture, office chairs, desks, equipment, maybe for a restaurant, like a coffee maker or a ice cream machine, something like that. So it doesn't cover those type of costs. Tenant improvements are typically limited to the physical improvements only. But again, this is a negotiated document as part of the lease. So if it's something that's important to the tenant and the landlord's willing to pay for it, then maybe they're willing to wrap that up into the TIs. And then one thing that's always addressed when it comes to the payment of the TIs is increase in construction costs. Because sometimes when you sign the lease, the estimate to do the construction is $100,000, but then the construction doesn't actually take place until several months or maybe a year later. And at that point, the construction costs may have increased, let's say by 5 to 10, 15%. How does that get calculated? Who's responsible for that? So that's something that needs to be addressed in the lease as well. And depending on the type of improvements, the type of tenant, the length of the lease, the monthly rent, the tenant improvements, ultimately who's responsible for it is negotiated. Sometimes the landlord is willing to pay for it as an incentive to have that tenant come into the space and lease it for a long-term lease. The landlord's willing to absorb that cost. Sometimes it's something where the landlord agrees to pay for up front, and then it's later on built into the monthly rent. So the tenant actually pays it back, but over time. So all those payment terms can be negotiated up front. Typically, as I talked about before, while the construction of the TIs are happening, the tenant doesn't have an obligation to pay rent. Sometimes where it's like an existing lease that they're expanding the premises, the tenant's obligation to pay rent will trigger immediately, but then the landlord will abate rent later on down the road, meaning they'll give them free rent for a few months, a year or 2 years down the road to make up for that rent that the tenant paid previously. So again, these are heavily negotiated provisions in a commercial lease agreement. So once the construction is done for the tenant improvements, the landlord's obligation has generally been completed. They've done what they were required to do to get the space in the condition that the tenant needs it in. So what the tenant work letter that's attached to the lease that we talked about earlier, that will define what it means to be substantially complete and what happens at that point. But typically what happens is the landlord will send some type of a notice to the tenant saying, the project has been completed. And then the tenant will have a duty to inspect the improvements, make sure that everything's good to go, sign off on it. And at that point, possession of the premises is provided to the tenant and their obligation to pay rent kicks in. What happens if there's some problems with the improvements that were constructed? Typically in California, you're going to be working with licensed professional contractors. They're going to have insurance. They have warranties on their work. So what happens is you would contact the contractor to have them come back and fix that work pursuant to the terms of the contract that you signed with them. And then one issue in tenant work letters and commercial leases is who's actually responsible to handle that process. Is it something that we want the landlord to deal with, or is it something we want the tenant to deal with? For example, if there's a floor that's put in for the specific use of that tenant, like a yoga studio, and then that floor fails, is it something that's better situated for the landlord to handle in dealing with the contractors or the tenant? So that's something to address in the tenant work letter. So in closing, tenant improvement negotiations are complicated but necessary in almost any commercial lease that involves modifying the property in some way for the specific use of that tenant. And tenants and landlords should be prepared when they're sitting down with a new tenant to negotiate those and have information that gives you a basis to negotiate those in good faith. You know, it doesn't hurt to get a rough estimate from a contractor up front so you know what you're dealing with in terms of what the ultimate cost and timeline is going to be before you start, you know, agreeing to do things in the lease. And then who's going to pay for it is obviously important. So the more information both the tenant and landlord have, the more beneficial the conversations regarding the tenant improvements will be. And then you can get it all documented into a nice tenant work letter, and the parties can hit the ground running. If you have any questions about commercial leases, negotiating tenant improvements, or just real estate law in general, please feel free to reach out to our firm. Again, my name is Steve Blake. My email address and phone number here on the slide. And I appreciate everyone's time, and thank you